Australian copyright law contains a series of tiered criminal offences for copyright infringement on a commercial scale or for commercial purposes. So these were significantly expanded in 2006 after the signature of the Australia-US Free Trade Agreement. We introduced a new category of infringement, or new criminal responsibility for infringement on a commercial scale, and broke up the criminal provisions into three separate tiers of infringing offences. So the way these operate, and it's quite complex in the legislation, but in simple terms, there are three different levels of criminal copyright infringement. The first, the highest level, punishable by up to 5 years imprisonment, is the indictable offences, or are the indictable offences, sorry. The indictable offences require people to be engaged in copyright infringement commercially or on a commercial scale, and has a fault element of intention or recklessness, which means that they must either know or be reckless that the materials that they are selling or distributing on a commercial scale are infringing copies. The summary offences don't require intention. They're easier to prove. They only require the fault element of negligence, that the person ought to have known that the materials that they were distributing or selling or copying were infringing copies. And the final category are the strict liability offences. These don't require any intentional element. They only require that the copyright infringement is engaged in for commercial purposes or on a commercial scale. These are further broken down to an infringement notice regime where law enforcement officers are technically able in Australia to issue fines, on-the-spot fines, to people engaged in commercial copyright infringement. I don't think we've ever seen these used in the last 8 or so years since we introduced them, but they do exist on the books. In fact, none of the criminal copyright offences get used very much in Australia. There was a big push to introduce them in order to combat copyright infringement here from 2006 in the Australia-US Free Trade Agreement, and there's still a push to do more about copyright infringement. But as far as criminal enforcement goes, we see very little of it in Australia. Note that there's still some uncertainty about the definition of commercial scale. We're not quite sure yet how many works or what sort of circumstances qualifies as commercial scale, but again, we haven't seen many prosecutions under any of these offences.